Hello and welcome. Thank you for joining us here today as we discuss how not to lose money on your government contracts. Hi, my name is Jason Chaka and I am a government contracts attorney here at MCT Law. I have experience managing contracts at two of the largest defense contractors in the world, and I would like to share a little of that knowledge with you here today. And with that, I would like to pass it around the room to introduce you to my team.
Hi, my name is Jessica Olens. I'm a litigator that's been practicing in front of the Court of Federal Claims for almost 7 years. I'm the immediate past president of the court's Young Lawyer Division, and I'm on the current board of governors for the court's Bar Association. Jason, why don't you tell us how we can save our clients money on their contracts?
Thank you, Jess. And really, that comes down to with how to appropriately react to unavoidable costs. And so, what exactly are these unavoidable costs? Well, none of us have a crystal ball. I'm sure when we were making our contracts back in 2019, none of us foresaw the effects that COVID would have. For example, let's say you had a contract where you're required to send personnel outside the United States. Additional costs associated with putting those people into quarantine, into transportation, into hotels, all of those were costs that we didn't foresee, or perhaps the burdensome federal regulations that arose out of COVID. How did that affect absenteeism in my company and in turn my contracts? And lastly, perhaps a topic that's a little bit more timely is the unfortunate situation in Ukraine. How will this affect my ability to perform my contract? Already we are looking at substantial increases in transportation and shipping and energy costs. All of these need to be addressed.
Is there any specific guidance the government has provided in regards to COVID?
Great question. I'd like to point out the fact that the DoD issued a memo as soon as COVID came to being. And in that memo, the Department of Defense really pointed to the issue that there is an excusable delay provision in the FAR. That is, if COVID caused you to miss your deadlines, you were allowed to increase in terms of time your contract. And it did hint towards the potential for reimbursement of costs on a case-by-case basis. But time is money. How all of these increases in time did increase costs. And so really the question is, how can I get that cost back? And really I want to highlight again, or another step is that increases in government scope. I'm sure we've all been in meetings, perhaps months ago, where your engineers were in a call with the government's engineers and you did not have a contracts professional in the room. And there was a agreed upon little bitty change in the scope. Well, over time, these little by little increases in scope can greatly add up and really affect your budget as you're getting towards the end of your contract. And so when you're at this time, months later, you're asking yourself, or the government's asking, well, where's the formal change order? And again, you're stuck in that position. And so really, what is the government's policy to ensure government's policy towards these unavoidable costs? Well, it's the government's policy to ensure contractors are made whole when the government modifies the contract or when there's a force majeure event. After all, contractors need to earn a reasonable profit. Otherwise, no one would perform government contracts. Thus, when you find yourself in a situation where there are these unavoidable costs, your first thought should be to request an equitable adjustment, or REA. And an REA is nothing more than an informal request to the government requesting a price adjustment in order to overcome some of these additional unavoidable costs. But when I say informal, they should still be in writing. And your main goal here should be to really get that change order through your normal relationship with your government customer.
Jason, what's a common roadblock you see with an REA?
Yes, with the FAR, whenever there's a change order, they're supposed to be mutual. I agree with the government agrees with me. All too often we see these change orders where they're unilateral, and I see small businesses lose out on these claims when there's clear verifiable adjustments, simply because really the underlying legal principles are sometimes confusing. And I just want to emphasize, when you see these unilateral changes in scope, you're entitled to a change order whenever there's a decrease or increase in the contract time or costs. And again, I want to highlight that this is an informal request. You want to clearly state the reasons why you should be entitled to an REA, but you also want to be careful not to add language which would cause an REA to become a claim.
So when you are prepared to appeal the decision, there's two avenues. You can either go directly in front of the Board of Contract Appeals, or you can go through the Court of Federal Claims. And there's a few benefits through going through the Court of Federal Claims. efficiently handling these types of complex, large technical litigation. The federal judges are more familiar with these types of cases, and they provide more consistent treatment overall. You're also going to be put in front of an unbiased set of eyes. You're not going to be butting heads with a contracting officer. And rather, the Department of Justice has that settlement authority. But it is important, even though you have a longer time frame to appeal within the Court of Federal Claims, you have 1 year. And so I would recommend reaching out early to MCT Law so that we can help you begin this process as soon as possible.
Thanks, Jess. And I wanted to highlight a great topic that you brought up. And for one, on these Board of Contract Appeals, the amount of information you get from the government is really condensed into a packet. And a lot of times you don't get into the depths of the discovery as you would like. For instance, let's say you want the issue for your claim is an issue with specifications on a contract. And so you want to reference back to a meeting between your engineers several months ago, and you know that there's specific meeting notes made, but you don't have those for one reason or another. When you're in the CFC, do you have the ability to get more of this information from the government through the discovery process?
Yeah, that's another benefit. So the court uses its own rules of evidence, very similar to the federal rules of evidence. You can use that discovery process within those rules to get those meeting notes. You'll have a bit more broad reach than going through the Board of Contract Appeals.
Yes, from the audience, I plan on challenging a procurement decision. Can I file that in district court?
Oh, good question. So actually, challenges to procurement decisions are under the exclusive authority of the Court of Federal Claims. So if you were to file in district court, it's going to be transferred or dismissed, causing unnecessary delays and additional costs. So it's very important. Reach out to MCT Law early. It will help you navigate that difficult process.
Thank you.
Sure.
Not seeing any more questions from the audience, but in a moment you will see our contact information on your screen. And I just wanted to encourage anyone that joined us here today to please feel free to reach out to us with any questions that you may have. And again, I wanted to thank everyone for their time, and I hope you have a great day.